Well, hello again. This is part 4 of this petition to the U.S. Supreme Court to stop removing women from their breast cancer treatment coverage while they're right in the middle of the treatment, aging them out, taking their money and barring them from the assistance they've been promised. Now, this one here is the first part of the petition, the reasons that there's 3 of them. This is only 15 pages. You only get 15 pages for this. So this is a draft corrected petition. So part 1 says, age discrimination after BAB versus Wilkie. That's this year. Age basis violation standard. This court's newly applied BAB mandate that certain federal decisions be made entirely free from any taint of age basis applies as well to the health care actions of Ramsey County and Minnesota DHS, barring age-based exclusion, denial of benefits, or discrimination in the state's MABC federal-funded program. BAB followed on the court's decisions in Azar, that's Health and Human Services Secretary, and Kezar, the VA, not to defer to federal agencies. Instead of deferring to VA's interpretation of the ADEA in its administrative hearings, because BAB is from the VA as well, and we're from the HHS as well, BAB imposed on the government a higher standard of age non-discrimination than on private employers. That's BAB, that's 11 to 12. You can read that at the BAB opinion written by Justice Samuel Alito, the majority. Now, under BAB, if age is a factor in an adverse federal decision, if it even taints any part, including administrative hearings, of the entire decision process, the age discrimination 29 U.S.C. 633A has been violated. It does not require proof that an employment decision would have turned out differently if age had not been taken into account. Age does not need to be shown as the key factor. BAB enforcement relies on 42 U.S.C. 1983. That's the Civil Rights Act. It's for civil actions, for violation of your constitutional and federal entitlements. Now, it relies on 1983 to remedy unwanted consequences of a clear standard of age discrimination, and not just any remedies spelled out in the statute. So that probably needs to be rewritten a little bit. It means that if there are some unwanted consequences from age discrimination under this clear standard, that the remedies available are not restricted to those in the statute. You can go to 1983, you can get prospective, injunctive, declarative relief, you can get damages, and I would say the statutory is in the statutory. So you got your statutory and your 1983. So petitioners have invoked 1983 at every stage from the first administrative appeal. We knew about this before we ever went into the administrative hearing. We said there was a colorable 1983 claim by the July 2016 MABC termination of the patient without any notice or justification, except the improper basis of change in age was given later. But at that time, there was no notice. So I'm just going to put later in here just so I don't leave it like that. Now, as the court below found, quote, respondents do not dispute that appellants' entitlement to MABC benefits represents a protected interest. For purposes of this appeal, we therefore accept that a protected interest is at stake. We next determine whether the procedures used were sufficient. To determine the adequacy of procedures, this court said, the Supreme Court in Mathews versus Eldridge, and that's italics added, the Minnesota Appellate Court dropped Goldberg to ensure adequacy of procedures and of the notice. So they're going with another case that doesn't apply to this. First time it's been brought up, Mathews versus Eldridge. It's a disability case in which the government just has to write to you and tell you you're no longer disabled. They don't need to have a hearing. So it doesn't apply to the fair hearings in the Medicaid Act. So in addition to the Age Act, which is directly applicable under BAB, in the proceedings below, we alleged the Medicaid Act, the 14th Amendment, procedural and substantive due process, equal protection, arbitrary and capricious clause as our cause of action in the administrative proceedings. And I don't know if that's cause of action. Yes, it is a cause of action. It gives cause of action. And claimed a violation of 1983. And contrary to the court below, this is the Minnesota Court of Appeals, appointed by Mark Dayton. Minnesota statutes 14.69 does give jurisdiction over 1983 to the Minnesota courts to remedy wrongful deprivation of cancer care. Now, the record clearly shows an Age Act violation requiring a 1983 remedy in BAB at 2. This is when the Supreme Court already found on April 6th. The majority found the government erred in thinking that for liability for age discrimination, that the statutory text requires something more than a federal employer's mere consideration of age in personnel decisions, unquote. The government, this is a quote again, draws the unwarranted conclusion that the statutory text requires something more than a federal employer's mere consideration. So the BAB ruling, this is the dissent of Justice Thomas, imposes liability if an agency's personnel actions are at all tainted by considerations of age. So that was a personnel action. This is a healthcare action. And Thomas lamented, this rule is so broad that a plaintiff could bring a cause of action even if he is ultimately promoted or hired over a younger applicant, unquote. However, the statute provides no remedy for the age discrimination violation, and you being the Supreme Court, relied on 1983. So what about exceptions? Is there an exception that would allow state of Minnesota and the county of Ramsey to run this as if they could eliminate people on the basis of their age? Well, let's look at the law. None of the exceptions or limitations of coverage in the Age Act in 42 U.S.C. 6103 or 43 Code of Federal Regulations 17.311 apply to justify the respondent's use of age to remove her or deny her MABC benefits during the time she requires treatment. And the law post-BAB puts the burden on the government to justify every taint of their age discrimination. And they have not met this burden and cannot. Were the government to belatedly offer an account of the need for their age-based actions as normal operations of a cancer care program or reasonably necessary to achieve statutory objectives, 6103 provides protection for these kinds of actions only if A, such action reasonably takes into account age as a factor necessary to the normal operation or the achievement of any statutory objective of such program or activity, or the differentiation made by such action is based upon reasonable factors other than age. 2, the provisions of this chapter shall not apply to any program or activity established under authority of law which A, provides any benefits or assistance to persons based upon the age of such persons, or B, establishes criteria for participation in age-related terms, or describes intended beneficiaries or target groups in such terms. So then, at respondents' insistence, however, the court below doesn't allow the full statutory scheme to even be examined, clinging to an untenable position that such inquiry is barred by the plain language of a single provision in the obviously initial requirements, which is subdivision A4 of that statute. That's Minnesota Statutes 256B.057, subdivision 10, A4. So this is why I'm doing this drafting. Now, but compare identical subdivision B, the very next line, where the end of coverage or limitations is actually spelled out as when the patient is no longer receiving the prescribed treatment referenced in subdivision A2. And let me tell you what subdivision A2 says to describe this program. According to the person's treating health professional needs treatment, including diagnostic services necessary to determine the extent and proper course of treatment for breast or cervical cancer, including precancerous conditions and early stage cancer. So these are the initial requirements, and that treatment still is continuing, and the limitations period of both the federal and the Minnesota law define that. And they do not define that in terms of age. So although the initial criteria is age, they don't allow women to get in the program if they're already 65. So there's a lot of trouble there. But these are people who got in when they're 62, 63. They just want to complete their treatment, and these people cut them off and redirect their funds to younger women. That is exactly what the court below said, the Minnesota Court of Appeals. This is really disgraceful. So, as such, this rigid interpretation undermines normal operation and blocks the stated objective of finishing treatment. And so, even if correct, it would violate the Age Act. Note also that the burden is on the government to justify use of age in taking actions and making age-based decisions. Since respondents completely controlled the forum and decision-making, they did not meet their burden. In fact, they barred petitioners from even asking the question whether this was age discrimination not supported by the statute. And this is in the courts, in the Minnesota courts. So, and actually, that was about the Constitution. So I'm going to correct that. They barred them from whether it was not supported by the statute for being unconstitutional in violation of the Equal Protection Clause. Okay. So petitioners, on the other hand, did meet our burden of proof to show that the county, on the basis of age, an elderly program, had terminated her in July 2016 when they began to charge her an age-based spend-down. The only argument ever given about their enunciated policy of excluding her and denying her benefits and treating her differently was her age. And the only support for that, and for all the treachery, impropriety, and dishonest, injurious treatment, was her age. Respondents urged that MABC is merely a temporary solution to a crack, a temporary fix to allow certain women to have a few proceedings from a doctor after they are diagnosed positive, but ending when they are removed and placed in a spend down to 81% of poverty because of the supplement to Medicare, which covers only 80% of some medical care in the MABC program. This contrasts with the stress on optimal care, optimal standard of practice in BCCPTA, that's the Breast and Cervical Cancer Protection Treatment Act, see Hauser versus Idaho, 2004. And you can look up that online. It's a very good case by Judge John Luster, excellent opinion, counseled case. And such a willingness in Minnesota to degrade the Medicare provided by the Minnesota DHS. So it contrasts with it. So this is an argument against the really unreasonable actions of and positions coming from our own Minnesota Department of Human Services, which is a part of the Minnesota Health Department. You'll see them in these press conferences talking about coronavirus. The AGE Act, which has been given new force and a private action, right of action for 1983 remedies, gives, with limited exceptions and coverage not applicable here, is equivalent in federal funded recipients for federal funded recipients to this court's new BAB higher standard of government conduct. So it has been given new force in the same way that the ADEA was given new force for federal employees. And it creates a duty of respondents here, Minnesota DHS in Ramsey County Community Human Services, to refrain from and protect against any adverse age-based injuries to the rights and entitlements under MABC based on age, and of age discrimination litigants, including the petitioners. And so this is the end. Yes, I know.